Good morning, ladies and gentlemen. Welcome to Al Company's presentation on the UAE Trademarks Law. My name is Omar Obidat. I'm partner and head of the intellectual property practices at Al Company, and I'm joined by my colleague.
I'm Shahnaz Disa. I'm the regional trademark manager at Al Company. Been here for 25 years and basically concentrated on trademark prosecution work throughout my career.
So throughout today's presentation, we're going to introduce to you the UAE Trademarks Law, which was passed in late 2021. And in this presentation, we're going to look at really what has changed from the 1992 law. The 1992 law was subject to various amendments and changes, mainly to comply with the TRIPS agreement, which was part of the World Trade Organization agreements. In effect, the law that was prevailing at the time before of the new law was already in compliance with the TRIPS agreement. However, changes that dictated compliance with the GCC Trademarks Law, which is a unified law as a model law presented to the GCC states in an effort to harmonize the trademark legislation in the GCC region. It was necessary to have a substantial change of the 1992 law. Furthermore, the UAE has joined the Madrid Protocol, and the accession of the UAE to this agreement came into effect in 28 December 2021. So there were changes that were important to be incorporated into the law. And we're going to talk to you today about these changes and understand, is this good? How beneficial is it to trademark owners, and what should you be aware of? Now, mind you, I have to start by saying that, Shahnaz, I think this is the most progressive amendment or reenactment of the trademarks law I've seen today.
Absolutely, it's come in tune with the rest of the world, and definitely the leader in the Gulf region for sure.
So, in the past, we used to raise comments about the law and issues related to multi-class filings. We used to talk about issues related to non-conventional trademarks. We used to talk about the challenges we face in cancellation actions. And in this law, all of these comments were actually adopted into the legislation.
Yeah, they've been all addressed, and like I said, it's basically now we can call the UAE the leader in trademark.
So very progressive law, very important changes. Fasten your seatbelts, ladies and gentlemen, and we're going to start by addressing what new rights and definitions this law has introduced. So collective trademarks. Shahnaz, this sounds like a trademark that is owned by a group of people. Is that what it is?
Yeah, a collective trademark is a non-traditional one where basically it's owned by an association. So are certified trademarks owned by association, but collective trademarks are owned by an association, and only members of that association can avail of that. Say, for example, a CA. You cannot use, it is a trademark, and you cannot use it, the term chartered accountant, unless you are a member of the association. That means you have basically completed the exams, you have reached a certain standard. So the association has standards or quality requirements. And if you're a member of that, you have complied with that, and therefore you can use it.
So, I mean, I've seen a lot of the agro producers will have a collective trademark. And if you're part of this agricultural association, you can actually benefit by using the trademark. So this applies to apple growers, it applies to dairy producers, and it makes it easier for them as growers or producers or farmers, because acting on their own and promoting a brand is more expensive, more difficult, whereas as an association, they have better strength, and hence the reason for it.
It basically certifies what you are, like the quality of what you are giving.
Okay.
Right?
So when you talk about collective trademarks, there are other like distinctive elements that we've seen over the years on various products. So brand owners were using holograms mainly as a means previously to distinguish the genuine from counterfeit goods. But here we're talking about hologram in the space of a brand, which is a hologram trademark.
Yeah, like we did, the American Express credit card, that's a trademark, that's a hologram trademark. So though 3D trademarks in the UAE have been accepted for a few years now, the hologram trademark, we don't have a registration as yet.
So this is brand new.
This is brand new, and it definitely opens up a lot of scope for trademark owners to register such brands. Right now, in my opinion, the process should be the same as a normal registration, but we will have to go further discussions with the trademark office, because there is a requirement at the time of filing an application that you have to describe your trademark. So how exactly, what is acceptable description for a hologram trademark, we have to still discuss with the trademark office and take it forward to get more clarity on it. But it is definitely now an acceptable trademark, and I see a lot of trademark owners wanting to register such trademarks in the future.
So this is very relevant to the financial institution, credit card companies.
Absolutely. Absolutely.
All right, geographical indications. What's the importance there?
Basically, geographical indication is a trademark which shows you a particular quality from a particular region.
Okay.
So, if you talk about Rockford cheese or Scotch whiskey, it's only from those regions that you can get such quality. So it's only if you're producing in that region that you can use these trademarks.
So let me ask you this, and we always hear this from clients who come to us with a trademark that incorporates the word Milan, or incorporates the name of a city, such as Paris, or a city such as Irish, a country referring to Ireland. What is the change here? Will this affect these registrations?
No, this is different. Geographical indication basically shows that this product has that quality from that origin. Now, using of geographical names is a different thing, which in a way it intersects, but it's a totally a different registration to a geographical indication.
So it's important here not to confuse between registration of a geographical indication and non-registration of a trademark, which may
geographical name,
which may deceive consumers in thinking that the origin of this trademark is from this region or not. Okay. Series trademarks, wasn't this already existing in the law?
Series trademark has been existing for a while now, except that now the new law has termed it as a series trademark.
So it was now it's coined as a series trademark, but before it was already accepted in
it was accepted. There are lots of registrations in the UAE for series trademark. So basically, it's the same trademark. The concept of the trademark doesn't change, but say the color changes.
So how do you go about it? If I want to have a series trademark, is there a special registration procedure for this?
No, it's exactly the same as a normal one. It's just that the label we submit to the trademark office will have different versions of the same trademark, or like it will be black and white in color, a combination of black and white in color. So it's basically the concept of the trademark is exactly the same, but you use it in different forms, different colors, and you want to protect all of them. You can in one.
So this is actually a cost saver, is it not?
It's a major cost saver.
Because you can have 6 or 7 variations of one trademark, probably in different colors or different forms, facing to the right, facing upwards, facing downwards,
Right.
and register them all as one trademark application, pay one fee,
Right.
and then you can alternate in your use.
Yes, that's right.
All right, wonderful.
Can I go back to the geographical indication?
Sure.
Just basically to point out that the UAE's new law states that if you want to register a geographical indication, it has to be registered in the country of origin. Otherwise, the UAE will not accept it. Another point also raised in the law is that if the new application for the geographical indication is confusingly similar to an already existing UAE trademark, they will not accept it.
Okay.
So these two are very, I think, important points to bear in mind when considering registration.
So basically, this brings us to what trademarks are incapable of registration. We know that you cannot register the emblem or the flag of the UAE as a trademark. You cannot register official names of official departments or states as trademark, or use international organizations such as the Red Crescent or the Red Cross or the UN as a trademark. And we have a few important changes in the new trademarks law. One is talking about 3D marks. And I know that 3D marks was typically acceptable in the UAE, right?
It's accepted. We've done quite a few for our clients. But basically, you submit 3D drawings of the marks. So you're not basically submitting a photograph, it has to be a particular drawing.
Has to be a drawing. Okay, so and this applied to really who? Was it more on packaging side or the shape of the packaging?
We've done a lot for jewelers.
Jewelers.
So,
the boxes that
the
contain...
boxes, actual design of the jewelry.
Okay, interesting.
So
it can be the product, it can be the packaging of the product.
It can be, yeah.
So this new law has really refined what can be registered as a 3D trademark, and said that those trademarks which consist of a functional shape that the rest of the industry would probably use to package their product, or if it really is a shape that represents the nature of the goods, then this is not a 3D trademark worthy of registration, and actually is incapable of registration.
Correct. Basically, it's going back to the basics of a trademark. So a trademark, the basis of a trademark is that it has to be distinctive. It cannot be descriptive of the products or services it's offering. So this goes down basically to the basics of a trademark.
So, this is a generic shape of a bottle, right? So I assume this bottle cannot be registered as a 3D trademark, right?
Yeah, if it is a general bottle, but say if it's a bottle with a particular different shape, then it can.
So the Coca-Cola bottle,
yeah,
for
yeah,
example.
it's distinctive in its shape, then it can be registered.
Very good. So packaging, bottles, etc., they can be registered as long as they are distinctive.
Correct.
So this doesn't change.
That doesn't change.
The law really has spelled out what we already know, but this was important to really fine-tune what challenges we were facing when trademark applications were under challenge by way of a court or an infringement or a lawsuit, and there was no clarity as to how 3D trademarks should be treated. Very good. Then we have translations and phonetic transliterations of well-known trademarks. I think here the issue was that well-known trademarks could be written in Arabic as a translation, or in Arabic as a transliteration. And actually, I mean, I think transliteration is even more serious because consumers will easily identify what the well-known mark is. But not only that, it is the fact that you can add letters in Arabic in the transliterations to try to make it different from the well-known trademark. These transliterations are now prohibited. Is there, in practice, I mean, do you see this in which industry where people copy transliterations?
In anything, really speaking. And what has been happening is that for a famous mark, say in English, if you translate it rather than the transliteration, because the transliteration would stand out during examination. But if you translate it, a lot of marks have managed to go through. So now with the new stipulation in the law, it clearly stops this from happening.
Very good. So then we have marks that create confusion either due to similar previously registered trademarks in the same class or actually in other classes. So the law says if you're registering a trademark in respect of goods that are not registered but can be linked to a previously registered trademark, then your trademark will be rejected.
Correct.
And I think that the best example we see often, time and again, is class 3 and class 18, which is perfume, cosmetics in class 3, and accessories and leather items in class 18. They're always interconnected.
So I guess going forward, the ministry will be more stringent in reviewing the other classes as well. Because earlier a lot of trademarks would pass through because some examiners would review what you call related classes and some would not. So now with the law specifying this, I'm sure it will be incorporated in the process and the training for the examiners that they have to review related classes as well.
So, you know, other related classes I've seen, which is class 36 for real estate affairs and class 37 for construction. I've seen class 29 for food items and 30 for confectionery, sandwiches, chocolate, etc. So many classes are always have a class that is tied to them somehow. But with the evolution of technology, it looks to me like everything is being done digitally and online. So whatever business you're in, you're going to have an app that people can log into your service and use your service. So this means there's going to be a lot of traffic towards the classes that incorporate the apps for software applications, for computer and technology related services, right?
Absolutely.
So having, you know, a preventive set of classes will actually help you push away competitors from trying to come close to your trademark. All right. Moving on, you just mentioned well-known trademarks, and you know, I'm curious: has there anything changed with respect to registration process, or?
Registration process is the same, but the law clearly states now what they will look for to determine if a trademark is well-known or not.
So the law talks about the extent of registrations a trademark will have in other countries, the extent of use the trademark has in the UAE as well as in other countries, how well does the public know and perceive this trademark? And all of these factors constitute this test that an examiner or a judge can identify this as a well-known trademark. Now, of course, if you have well-known trademarks, then you are protected without actually having a registration in the UAE.
That's
right? Okay, so you can oppose a trademark filed by another party based on your well-known trademark.
But the ministry then has to determine whether they term it as a well-known trademark if you don't have a registration here. Another thing they will look at is if you have a value on your trademark.
Okay, so valuation, this is new.
Valuation, it's new, not very clear on how they will evaluate the valuation of a trademark. But
well, in valuation of trademarks as an exercise, you can, as a trademark owner, bring a valuation report and submit it as part of your evidence to argue that your trademark is well known. And therefore, when we talk about this criteria, it's very progressive in basically that it's detailed more than it previously had detailed, right?
correct. Because it's now more clearly and it's set out as to exactly what they will be looking for.
All right, so very hot topic, multi-class applications. I mean, for many years, I mean, not many years, like every week, I get this question from clients that say, does the UAE allow for multi-class filings? Why is it so important for brand owners to have multi-class filings?
It reduces costs substantially because you're talking about one application covering several classes of interest to the trademark owner. Because if you're talking about, say, a food manufacturer, you're talking about 29, 30, 32 maybe for drinks. So you're talking about 3 classes, minimum of 3 classes.
That are core classes.
Those are the core classes.
We're not even talking about preventive classes.
No, just the core classes. So if you have multi-class registrations, it absolutely cuts down costs for trademark owners when the UAE has one of the highest official fees in the world.
So that's why it's so important.
It's a very important positive way forward. And I think it's also to do with aligning the UAE law with the Madrid protocol.
Oh, absolutely, it makes sense because the Madrid filings were coming in multi-classes.
Yes, and so they have to align themselves because otherwise they're not going to be able to accept Madrid system filings unless they have a multi-class system.
So alignment with Madrid, reducing costs. Does this mean that probably the number of trademarks filed in UAE will grow?
I'm sure it will, because one of the main constraints is the cost for trademark owners. When they come and they ask for a quotation from us and they hear the UAE fees, they kind of cut down the amount they're filing or don't file at all. So this will definitely.
So previously, I know that clients used to prioritize certain trademarks for filing because, like you said, the classes, their core classes are very important. So they may not previously have been able to register all their trademarks in all classes, but now it's more reasonable in terms of cost because you cut down the costs to one application, even if it's several classes.
And another thing which is good about the UAE is that trademark owners can register their trademark and get a very broad coverage because when they're renewing trademarks, they don't have to provide proof of use. It's only in an infringement issue that they will have to provide proof of use. So
we don't have the US model requirement.
No, so even if you want to protect yourself in other just preventive classes, you can do that with the multi-class application without thinking twice because the cost will be much lower.
So, and when we we talk about multi-class filings, we're really approaching an area where clients are considering how many classes. Is there a ceiling of a number of classes for multi-filing that where you can pay one fee, or is this still yet in the air?
This is still not decided.
Okay.
So we don't know whether it's going to be a smaller fee per additional class, or whether they're going to allow, say, 3-4 classes for the first application and then an additional. We don't know yet. So I guess they will inform us as time goes, once they're more clear.
So power of attorneys, I wanted to mention this because, you know, during the pandemic, if you remember, we had a lot of clients challenged with how do we get legalization done? We have to file, or we have a priority application that we want to rely on, and the legalization process is just too tedious during the lockdown. We cannot seem to get this done. In the new practice, what's the status?
So before the new law came out, in fact, the trademark office during the pandemic had eased these requirements, wherein they would allow us to file a trademark on a simply signed power of attorney.
Simply signed,
Simply
no
signed.
legalizations?
No, but the criteria is that you still have to submit a legalized power of attorney within 30 days of filing the application.
Fair enough, that's...
Or they would cancel the application.
Oh, so you lose your application?
So you lose your application. This is as per what they say, but in practice, I have to say the ministry has been very lenient. So there have been times when we haven't been able to submit, clients haven't been able to give us the power of attorney within 30 days. And we have written and requested an extension. So though they don't officially come back to us and saying that we grant you an extension of say 30 days or 60 days, they don't cancel the trademark. So they have been, but we cannot guarantee that that will continue. And another point is, unfortunately, this is only for trademark applications. It doesn't apply to oppositions.
Okay.
So for oppositions, we still need a legalized power of attorney. So hopefully in time that will change.
So oppositions, really, you know, when we talk about oppositions or objections, we think of the venue that we're going to raise this objection or opposition to. And previously, what we had in the 1992 law was we had the trademarks office or the registrar or the trademarks department. So the authority responsible for registering trademarks. And then beyond that, at a second level of review, you had the trademarks committee.
That's right. Yeah.
And then after the trademarks committee, you would go to the court of first instance, then you'd go to court of appeals, and then higher Supreme Court. So what has changed in the new law is that we have a grievances committee. And the way this grievances committee works is that it is not a trademarks committee of the same members that used to exist in the past, which had many members, predominantly members from the trademarks office, actually. So the same office that issued the refusal to your trademark is reviewing in the trademarks committee whether the refusal is incorrect or uphold that refusal, or whether the opposition that they've ruled against was a correct ruling or not. And in many cases, it used to be the trademarks committee will listen to the report of the trademarks office and see the summary of the matter based on the trademarks office presentation and accordingly decide. So it wasn't really a review, a proper appeal as such. It was an administrative review, right?
Right.
And now what you have really is more of a quasi-judicial administrative review. So in this committee, which is the grievances committee, where you can take your decisions related to refusal, related to opposition, and this committee is formed by 3 persons only. So you have a judge appointed by the Minister of Justice. So for the first time, this committee is not purely Minister of Economy. So it's heard by a judge and 2 experts knowledgeable in the trademarks field appointed by the Minister of Economy. So it's much easier to convene as 3 persons than it was in the past when it trademarks committee, where there was a lot of backlog, wasn't it?
There was a lot of backlog because in the trademark committee, they also had ministers from various departments. And then for all of them to convene and meet together, even though they were supposed to meet once a month, it didn't happen once a year sometimes.
Oh, wow.
So there's a huge backlog on appeals and
It was impractical.
it was not practical.
And you know, when it comes to these ministerial committees, the problem they have is most of them will be chaired by the undersecretary, and that undersecretary will have membership in a long list of committees.
Correct.
So they're always too busy to convene. And this one was a practical solution. Is not only they reduced the number of members, but also brought in a judge to allow the decision of this grievances committee to be appealed directly to the Court of Appeals.
Yeah.
So you're
cutting off
one appeal stage, which is the court of first instance, right? And this will reduce the litigation period for reviewing it or challenging.
And even the whole review process will be more streamlined because there are experts looking at the matter. So definitely, I think this is a major positive step, and hopefully the whole process will get streamlined and move much faster.
So you can bring the decisions to the grievances committee within 30 days.
Within 30 days.
And then you can appeal them to the Court of Appeals.
That's
cancellation trademarks. Very interesting changes there. We have, in the previous law, we had the trademarks department permitted to review cancellation trademarks, but in reality, they were not. So if you were to raise a request for canceling a trademark before the trademarks office, you can get a direction from the trademarks office telling you to go to court. But now it is a proper responsibility authority for the trademarks department to address cancellation actions. And not only do they address cancellation actions based on non-use for a period of 5 years, based on priority of ownership, because the brand owner claiming, requesting for the cancellation has used the trademark previously and therefore acquires a right. This incorporation of prior use was actually a right that was codified for the first time. Previously, we couldn't find it in the trademarks law, but we could find it in the judgments and court jurisprudence. Now it's been codified. So prior use has been specifically codified in bad faith. And this is particularly interesting to me. Why? Because trademarks that have been registered for 5 years and above and have been used throughout those 5 years become immune. So you cannot really cancel those trademarks. But in the new law, it was specifically mentioned that bad faith, if it was used to register a trademark, regardless how long this trademark has been living, whether it's been living for 5 or 10 years and has been in use in the market, bad faith can still be used to cancel that trademark. So this is a significant change in the area of cancellations. Now, when you do cancel a trademark, previously, the law will tell you that after canceling a trademark, regardless what the purpose was for canceling the trademark, you have to wait 3 years before you're able to register that trademark in your name, right? Yeah. So that wasn't practical really, because if I canceled your trademark on the basis that I am the prior owner and I use it, I have to wait for 3 years after canceling your trademark to be enabled as owner of this trademark. I mean, that sounds to me like a future that is not clear for litigants, because they're going to court or going to the ministry trying to get back their trademark, and they have a green light to get back their trademark, but they have to wait. The new law says that if you obtain a court order that cancels a trademark, that court order can incorporate any shorter period. So the court order can say that this trademark can be immediately registered in the name of the applicant for cancellation. And actually, I've seen that in practice where, despite the previous law, some court judgments were being passed to cancel a trademark and register it in the name of the plaintiff. And it was a court order that the Trademarks Office had to honor, but at the same time, it wasn't clear for them that we have to honor, but after having waited for the 3 years. This new law has really ironed out all those gray areas and gave a practical solution that if the court gives any period for re-registering a trademark that has been canceled, then that period will apply regardless of the 3-year wait period. I think the 3-year wait period comes from where it was aimed to protect consumers, really, because if consumers were used to a trademark that is owned by X party, then there should be a waiting period to allow the shift. And therefore, yeah. All right. So timeframes, electronic notification. So the timeframes for reviews, appeals, etc., have all been unified to become 30 days for objection of appeals. So if a decision was issued by the Trademarks Office to place a condition on a trademark or to reject a trademark, that decision can be appealed within 30 days to the the grievances committee, which will also be appealed within 30 days to the Court of Appeals. So that's unified there. What really changed was the explicit insertion of a 90 days for examination. What is the current time frame for examination, UAE?
First of all, there was never any specified time frame for examination. It's never been mentioned. So over the years, it's been quite erratic. At one stage, it would take a few months. But recently, in the past, I would say around 4 years, they've really brought down the examination process to maybe a week to a month. We normally get a decision within that time frame. But now, when it's mentioned that it's going to be a 90-day period within the maximum of 90 days, I think it will give the Trademark Office a specific period to work towards, but it will also slightly increase the time it takes to register your trademark. Right now, we're doing it in around 4 months, but the 90-day period will, of course, increase.
Yeah, so it does provide certainty that, you know, at least within 90 days you're available. And I think this is consistent with the harmonization of laws, etc., and also may help in avoiding situations where a priority application is being claimed within the 6-month period, though something has been filed and accepted within 1 week. So maybe that will address those conflicts. Email notifications for decisions. What decisions are notified by email?
Right, since the pandemic, every decision is notified via email now. And even the registration certificates are e-certificates now. Uh, Earlier, we had to go to the trademark office to physically make payments or collect the certificates, physically submit documents. So since the pandemic, in fact, this has worked out really well because everything is online, filing is online, publication is online, the certificates are received in soft copy now, payments are online. So any decisions they have, they send it to us online. In fact, even hearings are via Zoom at the moment.
Well, the issue of hearings, and we had some debate with the Ministry of Economy with regard to hearing of statements, and they were telling us that there was nothing in the law that that enables us to hold these hearing of statements for oppositions. And during the pandemic, there was no way to go to the ministry. There was lockdown, or you cannot access governmental departments. And there was that debate whether it needs a specific regulation or not. I haven't seen it in the new law, 2021 law, but the 2020 law actually said implementing regulations address the procedures and terms that will regulate opposition proceedings. And I'm hoping that it will be specifically mentioned that hearing statements can be held online, and with this day of age, there is no reason for really personal attendance for hearing of statements.
Absolutely.
So penalties. In the past, it was where the penalties had a minimum of 5,000 dirhams as a fine for any crime related to trademark infringement. And really the courts in general, not only related to trademarks law, but in general, the courts, when addressing criminal penalties in a criminal proceeding, for first-time violators will usually tend to rule towards the minimum penalty, in which case was 5,000 dirhams. And I remember we did research a few years ago for a client and looked at the number of penalties that were ordered by criminal judgments, and majority were 5,000 to 10,000 dirhams. And really those penalties were not deterrent. It's less than a slap on the wrist. And not only that, it was because of the nature of business, and entities can easily change. So companies can adopt a new trademark license, or adopt a new business license and appear every time as a violator or infringer for the first time. The new law has substantially changed the penalties and introduced penalties that range from the minimum of 100,000 dirhams to 1 million dirhams. But more to that, the law has divided crimes into severe crimes and less severe crimes. So the severe crimes were the crimes related to importing or exporting knowingly of counterfeit goods, possessing material to manufacture or imitate the counterfeit goods, or possessing in bad faith the counterfeit goods. To a less degree, yet still very deterrent, was the less severe crimes, with penalties ranging from 50,000 dirhams to 200,000 dirhams. And those crimes really are the normal sale or possession of goods. And when you talk about a retailer outlet, etc., it can be possessing or selling counterfeit goods. But if you're talking about an importer whose goods have been identified at the port or in a warehouse, and who had aimed to distribute those goods throughout the country, then that would be a severe case with penalties ranging from 100,000 to 1 million. Now, in case of repetition crimes, these penalties will double. So the maximum crime and the maximum penalty for severe crimes, which is 1 million, can be raised up to 2 million dirhams. And that's really bringing those, the crimes related to trademark infringement to become serious crimes, and preventing infringement, or at least preventing repetition due to the high fines. Now, we looked at the law, and we saw that this was an extremely progressive law. We've addressed some gaps that were in the cancellation actions. Now they can be heard administratively. We've addressed issues related to bad faith for trademarks that have been existing for more than 5 years. We've introduced holograms. We've introduced geographical indications, collective marks, explicitly mentioned series marks. We've detailed well-known trademarks. We have increased penalties to make them deterrent for crimes. The law also talked about email notifications and using technology as a ways to notify applicants. The appeal procedures have improved significantly to introduce this grievances committee, which incorporates a judge. It is only a 3-member committee, so it's practical to use. We've looked at the appeals from the grievances committee goes directly to the Court of Appeals, so shorten the period of litigation. All of these are positives, and all of these are areas where trademark owners have for some time been demanding that we require some changes to the cancellation clauses, or we require some changes to the function of the trademarks committee. So all of this has changed. We are yet to see implementing regulations also, which will detail some procedures related to oppositions or related to multi-class filings. We're yet to know whether or how the fees will actually be impacted for multi-class filings. It's going to be 3 classes like you mentioned, or is it an additional nominal fee per additional class? These are yet to be clarified in the implementing regulations. But overall, we have a significantly progressive trademark legislation. I'm very impressed. I mean, I haven't seen an area in the law that really says, well, I wish they had done this.
They've covered everything. They really have, and it's I think it's a bright future in front.
Very well. I'd love to take some questions if we have here from the audience. Let's check the.
On free zones.
Yeah, so the question here is, will the penalties that are incorporated in the new 2021 law for counterfeiting be applied to corporations or persons existing in the free zones or not? The trademarks law is a federal law, so it covers free zone in offshore and violations to the trademarks law with what it incorporates from criminal prosecution or civil liability will also to apply to all persons, whether they exist in free zones or onshore. So definitely, sure, free zones will be covered by these penalties.
The commercial license still required for trademark registration?
Yeah, that's a good question. It's always been the case.
It's always, the license is required, but it's always been the case that you don't have to register the license agreement with the trademark office. The new law has specifically clarified really, that you don't need to register the license agreement with the trademark office.
So I think the question here, really, Shanaz, was about the business license or the trade license. This is still the requirement?
It's still a requirement for UAE companies.
And you only need a copy, right?
Only a copy.
But if you're an individual, you don't need a trademark license. You don't need a business license as an individual.
See, as an individual, if you're based in the UAE, we have to provide a copy of the trade license to show that you are
A partner.
the majority, no, not just a partner, a majority owner of the company. Then only can you hold the trademark in your personal name.
So if I am an individual, I have to be a majority shareholder
of a UAE company.
To be able to register the trademark in my personal name.
Correct. But if you are outside the UAE, there's no such restriction. You can, an individual anywhere else in the world can register a UAE trademark in his personal capacity.
So foreigners or actually people residing outside the UAE have an upper hand in that, right? You can register a trademark as an individual if you're outside of the UAE.
Correct.
Okay, whereas in the UAE, you require a trade license copy or to be a majority shareholder.
And the trade license copy has to show that you're the majority shareholder.
Very good. Okay, well, the new laws have an international empowerment for UAE trademarks when it comes to oppositions to those classes of trademarks. Well, you know, each jurisdiction has its own trademarks law. So the UAE has its trademarks law. Its rulings and decisions impact the UAE alone. So if the trademark was considered to be incapable of registration in the UAE, this does not mean it is incapable of registration in Egypt or in Jordan. Likewise, if a party was found as being infringing a trademark in the UAE, that does not necessitate that the party will be considered as such. When it comes to oppositions, really, and this is true for many jurisdictions, when you go to the trademarks office and oppose a trademark on the basis of similarity or prior right, and you have a number of opposition decisions that were issued in your favor, although those are not binding on the UAE, nor is the UAE opposition decision binding on any other country. However, it can pretty much contribute to giving you the upper hand in an opposition proceeding where you have favorable decisions issued in your favor in other countries. So, and as a tactic, you will find that trademark owners who do oppose trademark application of a competitor and start to see that the outcome of the opposition is not favorable, they stop making these oppositions on the basis that they don't want to have a confirmed majority or global judgment addressing similarity between the two trademarks because of the opposition outcome. What's the next question, Shiraz?
We are registering a trademark in multiple countries in the Middle East. Do we still need to submit multiple applications by country, or single application would do? I think this is about basically doing a GCC trademark registration like we do one in the EU. So it's
still, this is too soon. The question is really, can we register a regional trademark based on the EU Trademarks Law? Quick answer is no. There is no plan for a regional trademarks office. The law does not address this. The GCC Trademarks Law is not about a unified office. It's about harmonized trademarks law. So each country will still have its own trademarks office, procedures, fees, but the legislation itself is pretty much similar.
The trademark licenses no longer have to be registered with the ministry under the new law. How the licensee will protect his rights in the market and in front of customs department or other official departments.
Can you rephrase the question?
The trademark licenses no longer have to be registered with the ministry under the new law. How the licensee will protect his rights in the market and in front of customs department or other official departments.
So where a licensee is aiming to approach authorities for protection of the trademark, that licensee must hold a capacity through a recognized or legalized document, and a power of attorney or authorization that is issued from the trademark owner to the licensee will suffice to approach government departments such as customs, if that authority includes the powers to record trademarks or attend to the protection of trademarks before that department.
And then we have this, the last two.
Do you think it would have been necessary to amend those articles related to trademark infringement criteria, i.e. European or UK laws?
In other words, the infringement criteria are not really clear, and it would have prudent to give it more clarification.
Yeah, I'll tell you, the issue really relates to the 1992 law. So the division of crimes based on severity was because the 1992 law combined all the crimes all together and put the minimum penalty regardless of how severe the crime was or how much bad faith this infringement carried. And it was a good step in separating between the types of crimes, and the criteria related to criminal prosecution remains an area that is regulated by the criminal procedures law. So this law, as well as any other law, would only specify penalties, and it's up to the public prosecution with the laws that govern their work to identify whether there is elements of the crime existing. So really the criteria, as you would put it, still lies with the general provisions of the criminal law and criminal procedures law, and the law had only divided the crimes into severe crimes and less severe crimes. So, okay, there we go. Yeah, so I think we covered all the questions. We've reached to the end of our session. We really thank you very much for taking time and tuning to our presentation about the new trademarks law. We're going to come back to you with further topics, possibly when the implementing regulations is introduced. And we hope you tune in, and thank you again.
Thank you.